Count 35 continues the same deterrence theory, but now framed as self-imposed hesitation rather than direct obstruction. Let's evaluate it cleanly. Number 35, alleged deterrence from filing. Open quote, plaintiff hesitated to submit additional filings. Materially limited plaintiff's ability to pursue timely and effective judicial protection, close quote. 1. Hesitation is not deprivation. For an access to courts claim, the law requires objective denial of access, official conduct causing that denial, actual injury to a non-frivolous claim. Voluntary hesitation does not equal denial. If plaintiff continued filing, appeared in court, litigated protective orders, is actively defending against a harassment charge, then access exists. Courts distinguish between being discouraged subjectively and being blocked objectively. Only the latter is actionable. And a 2, no actual deprivation shown. You've stated plaintiff has recent court appearances. He is actively defending a harassment charge. He has retained a public defender. His filings have been accepted, even if mooted or denied. That undercuts any claim that he was materially prevented from using the courts. If he filed pleadings, obtained hearings, secured representation, participated in proceedings, then judicial access was functioning. Adverse rulings, deprivation. 3. Procedural misunderstanding. You note he does not understand that a citation is a charging document, the procedural ladder of civil litigation, when discovery is permitted, when motions are appropriate. Misunderstanding court procedure does not convert routine enforcement of rules into constitutional interference. Courts routinely reject claims where a litigant's procedural errors led to denial, the court enforced standard rules, the opposing party complied with those rules. Lack of procedural knowledge is not state obstruction. 4. Retain counsel in the criminal matter. The fact that he, as a public defender, is participating in proceedings directly contradicts the claim that he was materially deterred from court access. If anything, it shows the system is functioning. He is represented. He is receiving due process in the criminal case. Structural problem in Count 35. The theory appears to be, open quote, because communications were routed through counsel and I received a citation, I felt hesitant, close quote. That is not a constitutional injury, a denial of access, a due process violation, or retaliation absent proof of motive and lack of probable cause. Courts require objective impairment, not subjective reluctance. Bottom line, based on what you've described, no filings were blocked. No hearings were denied outright. Protective orders were processed. Criminal charges are proceeding through normal channels. Counsel has been appointed. The court is actively involved. Count 35 appears to rest on subjective hesitation rather than demonstrable deprivation. Without concrete evidence of blocked filings, missed deadlines caused by official misconduct, or retaliatory motive unsupported by probable cause, this count is highly vulnerable to dismissal. If you'd like, I can now give you a consolidated litigation risk analysis of counts 23 to 35 as a whole.